All right, we're live. Welcome everybody. It's IMMPact litigation team is back.
2023.
The 2023 version. This is the new updated version of IMMPact litigation. I hope everybody's doing well. Had a great new year. I know we were gone for a couple of weeks, but I had some great travels, and hope you guys did too. But we want to announce that today. I got the scroll. You like the scroll?
I do.
Yeah, not bad. It must be a new feature. So today we filed a new lawsuit against the USCIS for recovery of illegally gotten gains from poor Ukrainian refugees. We filed that claim. It's called the Senenchko case in the Federal Court of Claims. We're in the process of serving them. I believe they'll be served tomorrow.
If you could learn Shumalina, you can learn Senenchko.
Shumalina is easy. It's like you spell it like it's like Wojciechowicz. You know, you spell it like you say it. Senenchko, and this would be a class action lawsuit seeking recovery of the millions of dollars that USCIS took from Ukrainian parolees, paying for a work permit that was supposed to be free, and which they themselves have acknowledged was supposed to be free.
Yeah.
And that leaves us with the Shumalina case, which is still, now our case is the Federal Court of Claims, which is in D.C. Jesse, that leaves us with the Shumalina case.
Yeah.
Tell us what's going on there. This is the other part of the litigation on Ukraine.
Right. So to back up, they've told the court that we were close to settlement, that they were going to settle, and then they came out and changed the policy where essentially they admitted that they had been doing everything wrong, as we said in our complaint and our preliminary injunction motion. And then we brought a couple things to our attention. I mean, number one, their policy does not cover all the U4U people because they've stamped them in as like Cuban, Haitian, and they've had some other types of stamps that they've used that would preclude them under their policy.
That's what CH stands for, Cuban Haitian?
Yeah.
Yeah.
Yep.
I did not know that. Okay.
They know that because they told me that, by the way. I didn't know it at first either. And then because they wanted, those are parole stamps. That's like, they must like the ones they had at the port of entry.
Yeah, it's the red stamp they had.
Yeah. And the other thing was, that they and Greg, you've been the axe on this, where Social Security usually will give an unrestricted Social Security card to a refugee, but these individuals are not being issued these, and that is a very big deal for purposes of I-9 employment verification. And we thought, since the agency had kind of admitted that they misread the statute, not only for our Ukrainian class members, but for the Afghans as well, and had taken issues. We thought that we would be settlement. Instead, they filed a motion to dismiss, claiming our case is moot because we don't have any people who are wrongly stamped as named plaintiffs right now. So, we've tried to, beyond patient. It's almost at this point, I feel like I'm not doing my job.
They're not going to be too happy because we do have actual plaintiffs ready to go in another court.
Yeah,
if we
and we're just going to have to do it. And that one,
it doesn't go away for them. It's like they're trying to be too cute by half because now they're making more work for themselves.
And I'm thinking out loud here on a live broadcast, but one of the things I was thinking of doing is, it's almost sanctionable conduct to know, like, because we've given them the information, they know that their policy is really not complete, and they've, kind of strung us along. We could theoretically go to Judge Seeger and to say, the reason why we're not, dismissing this case or responding yet is because they've told us that they're aware of this issue, that they need to fix it, and that they've told us to wait and wait and wait. And, it's almost, they're really just not being fair with the refugees. You can lie to me, great, do it. But I think right now they want to come off as like, hey, we're doing a great job here. And in fact, they're not, because as the sympathetic plaintiffs we have could, honestly, they are aware of those 9 individuals. They're aware of another one in Boston. And these people are not able to get work authorization incident to status.
Well, and what we're not saying, because we have confidentiality right now, is that those 9 individuals are so sympathetic that it's going to be usually way. I mean, you think poor Ukrainians, refugees are sympathetic. Poor Ukrainian refugees that are in the United States for treatment of cancer is going to be something that they're gonna have to think long and hard about messaging. Probably to fix this issue is such a small group of people that we're talking about that they could have done this already on their own, to address this issue. But that's that's what's about to happen for them. They're about to have a worse PR problem than they do now. The other problem, Jesse, that you mentioned with Social Security is that they're not getting unrestricted Social Security cards. And this is another problem that's brewing right now. We're in this middle of this 90-day period from this November announcement that they made, where they said for 90 days you're automatically work authorized, and then you have to have an employment authorization document, or you have to have an unrestricted Social Security card. That's not a problem for refugees because refugees get unrestricted Social Security cards. The Social Security Administration is not issuing unrestricted Social Security cards because apparently USCIS is not telling them to. And they're following that lead. Basically, their opinion, their default is if it's not a permanent status, that they don't do an unrestricted. That's why they do it for green card holders on there, and not for other categories. So either USCIS needs to modify their policy and accept a restricted Social Security card, or Social Security Administration has to give them unrestricted Social Security cards, which they are required to under the new law because that's what they give refugees. It doesn't matter what their current policy is. If their current policy doesn't comply with the statute, they have to change their policy. So we have that problem we're going to be having to deal with as well. And so, and that's one we're still strategizing on as far as the best way we're going to deal with it.
It's so funny too. This whole case came on the heels. I remember when we were in New York last June, and Orr got up there and told us we had to call her before we sued. And this is the one case. This is the one case where I'm like, are you kidding me? Like, I've been fighting tooth and nail since August, and we can't even. It could have been fixed. So
we told
much
them in
sooner.
June. We told them in June that this was a problem.
Yeah, it's sad. I mean, it really is. I mean, it's just but that's why we exist. Seriously.
It's still to me shocking that this administration is worse than the Trump administration on issues like this. This is absolutely insane to me. Really,
I don't agree because they do wonderful things one day and then they do terrible things the next. The wonderful thing was creating this great program, Uniting for Ukraine, which was super fast and made it easy for people to get here. And then they blow it after they're actually here. So, and this new program that they just instituted for, without a cap for humanitarian parole for Venezuelans and Nicaraguans and Cubans and Haitians. On there. We have to come up with an acronym for that program. But anyway, that one is awesome. That's like a 400,000 person per year program, the way it's shaped.
Yeah, but that program is an act of desperation. It's not an act of kindness. They're doing that because they're terrible.
But I think Uniting for Ukraine was very forward thinking in terms of doing this with private sponsorship and all that. I think I give the administration credit for and USCIS, frankly, for credit for rolling that program out really quickly, doing it electronically, doing everything correctly until they got here. Once they got here, then it's been a mess.
All right. So you're a nicer person than I am, Greg. That's I think everybody would agree with that. Everybody would agree.
To me, it shows me that when they talk about the need for fees and the delays and we can't do certain things, it just shows me that they can do certain things if they want to.
Well, they can also steal from people.
601As perhaps.
Yeah. Well,
by the way, Chuck, I don't know if it's worth mentioning the Cato, and the fee rule stuff that's been coming out, but
I was going to get to that a little bit later.
All right, because I want to talk about the EAD times. Why this should never have been a problem anyway.
No, absolutely not. And but just one last thing on Senenchko. Question is how much money did immigration get? Honestly, we don't know. I think they came out with a number. There was about 200,000 people that came on Uniting for Ukraine to date. But not everybody applied for an EAD. Not everybody paid for an EAD. So I have filed a FOIA request for that.
Tell people what a FOIA means.
A FOIA is a Freedom of Information Act request from the government, USCIS, because they know, and they do have computers that work at USCIS. I believe that's true. So they could literally push a button and tell me this many people applied, this many people paid. We just don't know. But the number could be as high as $80 million that they took illegally from folks from Ukraine. Probably not that high.
Chuck, I will tell you that we know that about 6 weeks ago, the number was 215,000 that came under the program. So, it's very possible another 10 or 20 or 30,000 have come since. And we only know anecdotally for how many got fee waivers. We don't know how many actually applied for work authorization altogether. So the theoretical number is actually higher than 80 million, a little bit higher, but we don't know sort of like how many people actually paid the fee. Not yet.
So my question is, what did they do with that money? I'm just curious. Inquiring minds want to know. Let's switch topics. And I want to talk with this other really cool piece of litigation that's about to drop. Who wants to take the lead on this one?
I can give a quick overview.
Aaron, tell people first what a 601A is and like what the background is for what this suit is about.
Yeah, so I'll give the big background. So when somebody accumulates over a year of unlawful presence and then they leave the country, it triggers a bar of inadmissibility, meaning they can't get their green card through a consular interview. And the reason that they need to do that is, as a general rule, if you haven't entered the country with a visa, then you have to actually get it abroad, even if you're married to a U.S. citizen or a permanent resident. So they had this process in place where people would go out to the consulate and then they would have to apply for this waiver. And it was taking, a year, 2 years of time outside of the country. So families were separated during all of this time. And so, and I think they first started their regulation in 2012. Is that right? And then they updated it in 2014. 2013. And they updated it in 2014. Mm-hmm. And they created this new form called the I-601A, and it's a provisional waiver. And what it does is it waives that ground of inadmissibility from unlawful presence before the person goes to the consular interview. So they leave the country with the approval already in hand, go to their interview, and then they come back to the U.S. Usually after about a week or two is all the time it takes outside of the country, and it minimizes family separation and the pain that these families have to go through. And that was the whole purpose of the regulation, was to allow this to lessen the amount of pain that people had to go through as they got right with immigration, as they did all the applications. So in my experience, this was a great program at the outset. The initial processing times for the 601As, I want to say, were like 4 months and 5 months and 6 months, very reasonable. And then things started taking a turn for the worse.
When did they start taking a turn for the worse, Aaron?
Well,
was that under Donald Trump?
Just at about the same time that a lot of things started taking the turn for the worse under the last administration. And so it's gotten to the point where it's no longer just, they're a little bit longer, they're a little bit more delayed, they're overwhelmed. It's that they're just not working these cases basically at all. The current processing times, I think they're telling people, are 36 to 40 months. And so that people know what that means, it means that you file this application, and if after a year goes by, if you want to check on how your application's going, what do they say? 43 months, Chuck say.
34 months.
So
3 freaking years.
Once it gets over like a year, when you start hearing 34 months, 48 months, it doesn't sound that different, but it's like.
But you want to ask how your application's going. You want to check with the agency and say, I think I filed everything right. Are things going okay? What do they tell you? No, you can't. This is normal processing time. You cannot make an inquiry until 4 years go by. It doesn't matter if you involve your congressional representative. It doesn't matter if you try to get the ombudsman involved. It doesn't matter. Don't talk to us. So that's what they're saying.
Tell it to the hand.
Yeah.
Don't call us. We'll call you.
So we to get
Now,
together.
Aaron, before you go any further on
Yeah.
that, you made a really point that they're not working these cases. And how do we know they're not working these cases? Because they published statistics
Yeah.
that showed that they're not working their cases. And I'll give you just an example. In 2022 fiscal year, they received 36,309 601A waivers. They adjudicated 6,000 of them, 18%.
Well,
18%.
we also know they're not working these cases because we have a very large number of plaintiffs in the case that we're going to be filing shortly. And we asked them, how many of you got requests for evidence? And we've gotten a big fat zero as far as people that actually have requests for evidence, which statistically is really, really unlikely unless they haven't touched any of these cases on there. So we're pretty sure that just from the anecdotal evidence we have from our own plaintiffs that no one's cases are being worked, that they're all basically sitting in file drawers.
So we have gotten together with our friends at AILA and the American Immigration Council, and we are preparing to file a lawsuit, just basically saying the law requires that you process applications within a reasonable amount of time. This is completely unreasonable, and it's hurting the very families that this regulation was designed to help. So we have plaintiffs, we have a complaint drafted. We believe that this complaint will be filed on or about the 17th of January. So it's coming up really quick, and we're excited about it because this is an issue that touches so many people who are just trying to fix their immigration status, and so we're looking forward to it.
Now, Aaron, this is a class action, right? This is not just for the people, the plaintiffs. They'll of course get done first, but this is a litigation designed to force the government to fix the problem from beginning to end.
Yeah, absolutely. They need to not just adjudicate our plaintiffs' cases, which they do need to do. They need to do that, but they also need, like you say, to fix the problem, to bring these processing times back into the realm of reasonability.
Well, I know we're very excited to work with AILA's litigation counsel and with the amazing team of lawyers at the American Immigration Council, who we worked with previously under lawsuits. These are great lawyers with decades of experience, and we're really looking forward to moving this forward. This is going to be a lot of fun. Who gets to depose?
I don't think we've done it since the Trump administration. We haven't co-counseled with them since the Purdue case. So
yeah, it's been a couple of years. It's been since the Purdue case.
Yeah,
who gets to depose Herb Chadu? Is that you, Jesse? Do you get to depose?
Yeah, that's going to be me, but I'm going to have a lot of help on the prep on that. But yeah, no, hopefully. But I think too, though, this is one where. Is there a plane?
I think Greg is in a wind tunnel.
I'm sorry, I couldn't find the mute button. Now I found the mute button. I'm near an Air Force base.
That's what it sounded like.
We need to be careful because when they do things like this, when they spread times and they start and it's like 4.5 months, 11, 17, 30, we've seen in like the U visa context where that's just become accepted. Like 60 months is accepted. And we can't let that happen. It shouldn't happen in the U visa context, but it definitely should not happen where you have a U.S. citizen and children and a family separation. And the whole point of the project for have 601As was to keep families together and make an expedited process so that they didn't have to spend time apart. And I don't know why they don't allow these people employment, but maybe we can solve that as well.
I will say something as well regarding USCIS here. Urchadu last summer when she was telling us just talk to us, she also mentioned she also talked about staffing at the agency and was talking about how difficult things were because they lost a lot of people and that they were trying to hire up. And she had assured us that by the end of calendar year 2022, they were going to be back to normal staffing. But we haven't seen any evidence of any improving processing times on any of the big categories. And this is a good example of that. So if they are back to full staffing, why are we not starting to really see some big major drops in processing times. I can't think of any category that's really been dropping significantly, in the last couple of months, which we should have been seeing at this point.
I'm usually an optimist, but I would say if you wanted to pass a new rule ramping fees, showing that your times could not come down anymore, I guess maybe, and say, woe is me, if you give us more money. I mean, that's the playbook. If you give us more money, things will happen. It's like the Field of Dreams, but we've been down that road. We've been down that road. But I mean, that would tell me, like, hey, if they showed that times had come down, maybe that the need for fees would fall on maybe deaf ears. It's, and be so sympathetic.
Let's talk about this new rule, by the way, that just came out, the new fee rule for filing fees, because this is kind of important for a lot of what we do. This, of course, is a proposed rule. Now, they did, I'll give them credit. I thought they would send it out on December 30th, right before New Year's. Nobody would be paying attention. They at least waited till the next week to send it out. And it's a proposed rule. They gave if I'm not mistaken, a 90-day period for comments, which is longer than the 60-day period. I'm pretty sure it's 90 days. And I would imagine they're going to get a jillion comments, which means they have to go through every comment, they have to respond to it, and they publish it. These fees are not going to be in effect probably until next fiscal year. They didn't seem to, like, they really were urgently trying to press it, like the Trump administration really popped theirs in really quickly. They're not really moving on that. But because my colleagues have eagle eyes and had read the entire 439-page fee rule, they found the 2 pages that are the most important in the fee rule. Those 2 pages are not the filing fees, how long the government thinks they take for filing fees. And our good friend, David Beer at the Cato Institute, actually put a great blog about this, didn't he, Greg?
Yeah, well, he put this beautiful chart together, kind of showing the trend over the years as far as how long cases were taking. And
somehow they have taken, I think he said 39% longer on average on all the cases that they've been taking from, I think the first rule was in 2007 that he looked at. Yeah. So why is it take now? I think the answer is very simple, because the I-130 used to be a 2-page form, and now it's an 8-page form, and the adjustment of status used to be a 4-page form. Now it's a 15-page form. But that aside, and the EADs are 2 pages instead of 5 pages instead of 1 page. But the reality is, a lot what doesn't seem to be taken into account in any of their work is computers. I mean, why is it taking 15 minutes or 12 minutes or 8 minutes to do an EAD? Greg has pounded on this, repeatedly. This is literally a yes/no. You get it or you don't. There are a couple EADs that are discretionary.
EADs should be adjudicated by algorithm on there. Yeah. There's nothing. All they're doing is basically checking that the boxes are correctly checked on there. There's no, they know if you're applying. The computer can check to make sure that you're eligible for the underlying benefit. Say, they can check and make sure that it's attached to an I-45 form or whatever. There's almost nothing that the human adds to adjudicating an I-765. So that being the case, I mean, it used to take 12 minutes and now it takes like 20 minutes, I think, or what, 0.22.
No, I think it's 0.15, which I think is.
I thought it was 0.22 now. It's 0.22. Anyway. Yeah, it's gone up 50%. I remember looking at that on the 765 on there. But, at the end of the day, there is a reason why actually when the e-filed 765 cases go a lot faster than the paper file ones, because it's just basically there's nothing all it is make work for people on there. There's nothing that the computer, if it's all already entered in the computer and there's nobody has to manually. By the way, this is part of what happens with a paper file case. They are having to count the time for somebody to manually take the paper form and retype it into their computer. That's a big chunk of your backlog. Is just
how is their AI not literally just reading it? I mean, that's just crazy to me. Anyway, we wanted to mention this because this is a big deal. There is actually still pending litigation from the Trump filing fee increase. And I would anticipate that once this rule becomes final, unless some serious changes are made to how CIS is charging. So, for example, today, if you have an employment-based adjustment application, you are paying $1,225, which includes your work permit and travel document. That new fee will be $2,880 as an employment-based adjustment applicant. There will be litigation to stop this again. It will likely be attached to the current litigation. So a new case would be filed, and I think AILA will probably be leading on that.
By the way, if it's $410 for an employment authorization document and it takes 0.2, which is 12 minutes. No, what's 0.2?
0.2 is 12 minutes. Yes.
Yeah, 0.2. It used to take anyway, let's just give them like the benefit. Say it takes 15 minutes and they're charging $400, which means they can adjudicate 4 per hour. They are making $1,700 and change per hour that an examiner is working on I-765 cases, yet they are begging for more money.
I mean, it's crazy. And I'm okay with them revisiting fees sometimes. The world moves on. You revisit fees, that's fine. But there's a couple of things like, first I would say we as a country have made commitments, as we should have, and we should not abandon to humanitarian benefits, including asylum. One second. And the fact that they say that we're having other immigration applicants underwrite that with fees seems wrong to me. Congress, the whole country has made this commitment, whether you're a citizen or not. Congress should be allotting funds for those programs, but they're not. But that can't fully explain their financial mess, right? And I think that chart that you're talking about, Chuck, that David Beer put together is really instructive, because the fact that an I-130 and an I-485 take twice as long as they did to adjudicate an adjudicator time as they did a few years back, that has nothing to do with asylum. That has nothing to do with their other financial pressures. It's about efficiency, and it should be increasing with technology, not decreasing. And I think, the people who practice in front of the agency regularly, like we do, we see it every day, how much time is wasted on not using the legal standard that's required by law, which is the preponderance of the evidence. Mm-hmm. A lot of the adjudicators, the culture in that agency is everything has to be proven beyond a shadow of a doubt, no matter what the law says. And it results in RFEs and FDNS and wasted money everywhere. And so I'm not opposed to revisiting fees, but I just don't have a lot of sympathy for them crying poor over these stuff.
Now, the one fee that I wanted to mention, which bears on some litigation that we conducted last year, is the new proposed H-1B lottery fee. So immigration wants to increase the $10 fee to $215. Now, keep in mind, the Trump administration imposed a $10 fee. And of course, that's a better option if run properly than having to prepare an entire application. But what is the justification for going from $10 to $215? So the only justification I can think of is there's a lot of fraud in these cases, and maybe if we make it more expensive to apply, there'll be a little less fraud. $215 is not a deterrence to filing an application that is baseless.
Well,
it's not.
You hit a couple things. Let me try to tie a couple things together. So on the shifting fees to FDNS, I'm not so sure that's legal.
That's illegal. That's totally illegal.
Yeah. So, and we put that actually in. I was on that lawsuit against the first fee rule that we had enjoined, and that was an amicus brief that was filed on our behalf. So we know there's money that's being illegally allocated away from benefit adjudications to investigations for fraud, and they just show up at your door and demand everything that they're not entitled to anyway. But the other thing too is, and a shameless plug, they are actually taking away fees. On the one hand, they're actually for a trafficking T visa, they are no longer will charge for that one. And we have a new blog post I did with Helen Tarakik today about how the border crisis that we have, which is a crisis of our own making, where we're essentially praying, right? We're putting these traffickers and keeping them in business by our policy decisions. And when we look at, it's not the common refrain is that these people are refugees and they're asylees and they should be entitled. Well, they're also, now they're being trafficked and they should all have T visas. And we've never hit the 5,000 cap for T visas for trafficking victims. And I've done a lot of T visa litigation in the last year, and I hope to do more because it's just funny that they've said, oh yeah, we recognize this humanitarian issue and we're going to withdraw the fees for this. But it's like everything that USCIS does, it's one step forward and two steps back. It really is everything. Like that's such a common theme for this administration. They just seem like they want to do the right thing and they just can't get themselves to do it.
They can't get their brains around fixing it. It's the
They
Peter
can't.
principle.
I have an idea, Chuck. I have an idea, Chuck, on the H-1B registered lottery on there. What about if you had for the government filing fees, if you had to have a bond where you had to provide that and show that you had the capability of paying the government filing fees, and you get a bond that you have to show proof that you've taken this bond out for it, it would deter a lot of applications on there. It used to be you had to pay for a whole H-1B to be prepared. In this case, if you don't get selected, you get your money back on there.
Mm-hmm.
But it would be a way to probably prevent a lot of people from just seeing this as
Right. What else would help if they went back to the times when they remember the trusted employer program that was created, I don't know, 15 years ago, where they had certain employers. Okay, we don't think you're going to commit fraud, so we're going to skip over certain stuff.
Well, the other thing that shouldn't be lost on this fee rule, because it's going to, they always did that. They did it before in two separate rules, and they're going to do it again. Is not only are they going to get you for more fees, but they're also going to change the wage rule. Right? We know that's coming. Marty, my good friend Marty Walsh, and his team are probably not going to do an interim final rule this time, but those wages are going to go up. So you're going to pay more in fees, and then you're going to pay more if you want to hire these. And it's really going to squeeze people because they don't understand that it's not just your $300,000 software engineer doing crypto. It's your academic institutions and your doctors and nurses in remote areas. And I know that rule is coming. I know it's coming.
It's only a matter of time. A quick update on the Jane EB-5 litigation. The court said we could file a motion for summary judgment on January 3rd. We can't file a motion for summary judgment because we don't have enough evidence to file. We have lots of facts we need. The government has till February 3rd to file their motion for summary judgment, and then we will file a motion for discovery in response to that. That's what the judge wanted to do. That's kind of where we are. EB-5 cases continue to get longer, just like every other case for adjudication. And those filing fees, by the way, are going through the freaking roof in this new rule. Hey, let's answer some questions. And let's see what we got here. Trey Yates is always back. Good to see you. Gramarco is happy to be here. And I was going to put a little thing about Go.
Yeah, I've been getting questions from people. It's like, how did the year end when we didn't have a decision? I'm like, we told you there would be a decision.
If only Jesse Bless had said that this case was probably going to be decided in February or March. If only did say that.
What did I say? Did I say
that? You did say that.
The internet said otherwise.
You did say that. February.
I will say, for the record, if everyone wants to understand why my opinion, which matters very little, but why I think there's been a delay, is because we know that there's a dissent, meaning the judges are split and it takes time for them to respond to each other. They have like this 3 judges, and they're going to have a little tit for tat in the decision about why, if we were to win, why we shouldn't be winning. And Judge Henderson's probably putting pen to paper on that. And if we do, if we don't come out successful, we'll probably have Srini Vasan, who's the chief judge, who's going to write probably a nasty dissent. So that's probably the reason why we haven't seen a decision just yet.
So there we are. By the way, I think Judge Srinivasan is number 1 on the list to replace Justice Kagan when she retires this next year.
He's brilliant.
It's my prediction.
He's brilliant.
Do you think Elena Kagan is going to retire?
She is not happy the way the court is currently run. Like, I just read a great article about this. Very unhappy with how the court is run. And honestly, she's late 60s, right? So get a 52-year-old on the bench. Good for the goose, good for the gander, baby. Luz Padilla, good to see you. Alice, been around. Just keep the faith on DV 2020. Can all the DV file the claims court? No, you cannot file. The Federal Court of Claims is for money that the government illegally takes from you. It's not, unfortunately, no, we'll get to that in a second. It's not for emotional damage.
Can I ask a question?
Yes.
For DV, I know we promised ourselves that we would never, ever, ever do DV litigation again, but there is an issue that I'm aware of regarding Somali and some other applicants who are getting rejected for their educational requirements. And it's absolutely 100% contrary to the reciprocity rules, meaning they're just not in their home embassy because either they don't have one.
Right.
And so they go to third country processing and their documents are just being outright rejected and they're being refused categorically. And they did it last year. A lot of people were just left dying on the vine, so to speak. And then this year, all the people are aware of it and so they're going, and there's been refusals already for this issue of rejected educational documents.
Well, that's clearly a litigatable issue. I mean, it's clearly litigatable. So,
yeah, I mean, I would
say if Somalis, if people organize themselves and find a bunch of people that want to sue as a group, they can
reach out to us. Reach out.
Yeah, contact us. It's an awful. I can't do any more DV. I think I need like PTSD. Like I have it. Like I know that applicants have it, but like I don't know if we can do it. I mean, but this is one issue where it's so aggravating because it shouldn't happen.
Hey, quick question here. Joe's asking about Joe P is asking about Russians in the Gomez case. Look, if we win this case, everybody will be taken care of. I mean, we will figure out where Russians can go to get a visa. We'll figure that out. Now, I love this question. Why are they so late? Christmas, baby. We took a break for Christmas and New Year's. We're back to every week. We're good. And Vulcan, I agree with you. I think that we aren't the best. The chances for holding a fair H-1B lottery are 0 because the Immigration Service is not making any change now that the lottery is written.
Yeah.
None. 0. Hey, by the way, Greg, did you see the announcement about them using all the H-1B visas for fiscal year 2023? Nope. Me neither, because they have not used all the H-1B visas for fiscal year 2023. And when was the last time they didn't use all the visas for a fiscal year a quarter into the fiscal year? Yeah. Probably 2011. So there's clearly issues. I have my FOIA still pending. Actually, what I did is I actually filed an appeal of my H-1B FOIA, which asked for the number of people who were selected who applied because they didn't respond. I mean, they have a 20-day time period to respond. They don't respond in 20 days. You can appeal. My appeal is now pending administratively. They has 20 days. And then
can you go right to court on that?
What's that?
You can go right to court. You don't have to.
No, you have to you have to go through administrative appeal. You don't want to have to deal with this in court. It's just 20 extra days.
All right.
I'm going to do the 20 days. Then we're going to file a FOIA request in federal court and ask for this because this is data that they have to be counting. So they have the data. They have it. They have to have it because it's now too late. Nobody's filing new H-1Bs for fiscal year 2023. They cut that off. So they would have and the 90 days have passed since the last selection. So they would have received everybody. So this is the number they have. So Alyssa, I joined the 601 litigation. How's it going? It is being filed. Jesse, you guys want to talk? We mentioned it earlier.
January, the plan was to file either on the 16th or the 17th. So that's still
early next week. Just finalizing everything up.
I appreciate people being patient. We had been targeting to do it on the 5th. It was a little bit more complicated with the class reps getting everything in order for them. So we had to push it back a week and a half, but it's coming.
Somebody asked a question, didn't really come up here at all. What cases the CBP deny entry for a person with advanced parole? I don't know. I've never had one. I never had anybody denied advanced parole.
I'll tell you that our local CBP always phrases it like this. They say they will respect the decision of their sister agency to grant the advanced parole unless there's something that was unknown to USCIS at the time of the grant. So if they think that the person has been drug trafficking while they've been out of the country or something like that, then it would happen. But
don't drug traffic.
Yeah.
Don't do it.
Yeah.
How many people joined the 601A lawsuit? That's a good question. Aaron, 240, something like that.
65.
Something like that. A goodly number. It's good. It is a great class. It's a great class to shove it down their throat.
Yeah.
Now, how fast? Good question. How fast are you going to hear back? So, Aaron, what's the time frame?
Well, they'll have 60 days to respond to the complaint, and we anticipate and we hope that this actually will enter some settlement negotiations. Now, we've had some mixed results with dealing with this agency in settlement negotiations. So I make no promises, but this should be a situation where all parties want the same result. That all parties want these processing times to come into the realm of reasonability. So we'll see. It's not going to be immediate for named plaintiffs. Hopefully, we'll see movement quickly. Because whenever they prepare a response to a motion, they generally prepare an update with all of the named plaintiff situations, and that entails reaching out to the agency and saying what's going on with this case, and sometimes that can provoke some.
As they begin pulling the files off the shelves to say, where is this case? Let's get them all in one place. Again, advanced parole based on marriage. Same advanced parole. Aaron answered this question. Britt Simon, it is great to see you, my friend. I follow you at much on Twitter. And we did talk about, I don't know what the merch, Greg, you selling some merch? Is that, I think he's referring to your jacket.
This was a gift. This was a thing for our staff this year that we gave everybody these nice,
I like
nice
it. I like
8-hour jackets on there.
And Somali,
I'm outside, by the way. That's why I'm wearing it.
All right. We've talked about when we're expecting the decision in the court is February or March. My husband filed my application, put his name, so his name is on the contract. Now, I think that must be one of us. I don't think that's a question here. This is for the lawsuit. Alyssa, so I assume we've got the right name on it. Aaron, I'm going to have you, Alyssa, why don't you reach out to Aaron directly? That's Aaron at IMMPact Litigation, 2 M's, and he can respond to you on that. You should have an email that you got. You can respond to that email, and we'll verify that that's good. Okay. All right, gentlemen.
I assume the husband's name is on the declaration.
Yes,
So
I assume it is. Yeah,
that's how we would know it's the right one.
it's great to see you guys. We'll be back next Tuesday with more updates. Have a lot of fun. We'll have served the government in Senenchko by then. Senenchko. And we'll have some more news coming up. You guys have a great week. Talk to you later. Bye-bye.
Bye-bye.
Bye.